Right, from there to have it repaired.
All right. Now, you're suing for $550, right?
Yes, sir.
How did you come up with that?
I came up with it, that was for the repair of the radiator. I had to get a car, I had to rent a car.
All right.
To get around and go to work. And also, I believe that I included the court costs and the filing fee in it.
Okay, let me see what you have, ma'am.
That was the cost.
All right. This is from Volvo only.
Right.
7 Mile in Detroit.
Right. Once I find a good business, I usually continue to patronize. I don't go around back and forth. That makes sense. And then this is for the rent-a-car.
All right, so from Volvo only, you replaced the radiator. That's what they did here, looks like. And you paid them $318.90, right?
Yes, sir.
Okay, now you've got something here from Enterprise Rent-A-Car, and it looks like you have to pay them $189.48 for a vehicle to rent.
If a business says they're going to fix something, the business should fix it. If the business breaks something, the business should repair it. Let's see what the defendant says.
Mr. Williams, first of all, what's your relationship with Valvoline Instant Oil Change?
District manager, sir.
District manager?
Yes.
Okay, so you don't own the company in any way?
No, sir.
Okay. What kind of a company is this?
It's a limited liability corporation owned by Marathon Domestic.
Okay, and you just run the place?
Yes, sir.
This is not you're not the franchisee or anything like that?
No, sir.
Okay. So you work for the company then, and they pay you a salary to run the place?
Correct, sir, yes.
All right. Well, what about this radiator problem? Tell me about that.
The radiator problem occurred in my location. I spoke with Ms. Webster that day or the next day. I explained to her, ma'am, you have a vehicle that's 1990. Things are bound to happen. High mileage, brittle, dry, things happen. I said my technician attempted to take the radiator hose off. The radiator neck broke. Reason being because it was dry and brittle and dry rotted. And I explained to her, I'm willing to go half with you, ma'am, to reimburse you half of your costs on this radiator. And she agreed with that. Next thing I know, I got served court papers.
Well, why should you pay half? I mean, you're not, let me back up for 1 second. You're not disputing anything that Ms. Webster said, are you?
No, I'm not. No, I'm disputing, no, I'm not. Only thing
in terms of the facts, you're not arguing with, I mean, everything she said is true, right?
Yes, I'm just adding one added piece to this. The car is 1990. Well, the radiator hose, the neck is dry and brittle. It's bound to break. I'm sorry that my technician, we do radiator flushes many times. And
well, yeah, but I don't understand why you think you should be liable for half. I mean, it was your technician that broke it. It's his fault, right?
Wouldn't the agent of the car also have a problem to do with that, sir?
Yeah, he's got to be more careful, or not do it.
Sir, we are careful, sir. I mean, things happen, sir. Sorry.
Well, I agree, things happen, but if you are going to be in this business, okay, of changing oil or changing radiator fluid, part of that means that you have to be able to do it without damaging the vehicles that you're working on. Now, if you can't do that, then you can't do the work. Now, maybe you need to have some sort of sign, or you have to have some sort of policy where you simply say, we're not going to work on vehicles or at least change the radiator fluid if they're more than 16 years old or something like that.
Maybe we do, yeah.
Because we can't be responsible for what might go wrong. Or you can have a policy that says we reserve the right to refuse service on vehicles that we deem are too old to fix, or something like that. But if you go ahead and fix it, or attempt to fix it, then you're liable if you mess up. And that is, I guess, the risk you take by engaging in that business. If you can't do it, then you shouldn't do it to begin with. You understand what I'm saying?
Totally understand, sir.
All right.
Just because the car is old doesn't give Valvoline the right to break it. The judge should rule for plaintiff.
Now let's deal with the other issue, whether you personally should be sued. And I think you're right there, Mr. Williams. Ma'am, I can understand why you sued him personally, But this is a big company, a limited liability company, and we don't need to get into all the legal stuff of what exactly that means. But what generally it means is if you're a limited liability company, the company is liable for anything that it does wrong within the course of its business. Well, this happened within the course of its business. Essentially, the company was negligent in draining the radiator fluid. If the company or the worker was negligent in draining or changing the radiator fluid, it was done within the course of that worker's business, which means that individual worker, or the manager in this case, can't be sued. The company is liable for it. That's why you create these kinds of companies. You know, I don't have any documentation here to show that Mr. Williams is the owner of this store, or this, not really store, but this service station, I guess you want to call it, this place where you get oil changed on your vehicle. I personally am not familiar with the corporate structure of Valvoline Instant Oil Change. I don't know how they're organized. It makes sense for me to believe that this is owned by another entity, such as a limited liability company, that Mr. Williams would be the manager instead of the owner, because typically that's how these things work.
Well, he said he was the owner when I talked to him.
You say that,
He
sir?
offered me $200.
Well, just because he offered you $200 doesn't make him the owner. He's the manager. He has authority on behalf of the company to settle something like this, okay? That's his job, but that doesn't make him the owner. It doesn't make him personally liable just because he's offering to settle with you. He's telling me here that he's not the owner, and I tend to believe him just because I think the way these things are set up, that they don't have necessarily individual owners to them. So I believe him as far as that goes, and that being the case, he's not personally liable, but the company is. So I am going to enter a judgment in favor of the plaintiff, but the defendant will be Valvoline Instant Oil Change. And I'll amend the judgment, or amend the complaint to name Valvoline Instant Oil Change as the defendant. And Mr. Williams, I'll take it or assume that you will make certain that Ms. Webster gets her money, not from you personally, but from the company. Within 7 days. And the judgment will be for $508.38, and that's for the money that you had to pay to get the radiator fixed, and for the money that you had to pay to rent the car. I'll add to that cost, consisting of a $25 filing fee and a $23 service fee, bringing the total amount of the judgment to $556.38. All right, I hope everybody learned something here from this case. Have a good day.
The judge had me worried there for a minute, but I'm glad he corrected a technicality. Technically, the defendant was not sued personally. He was sued on behalf of the company. The judge made the correction, and he made the right decision. If you find that you are involved in a dispute that you can't resolve, small claims court may be the answer. Thanks for watching Case Closed. I'm Charlie Langton.